Let's go to the White House right now, where President Donald Trump has more harsh words for House Democrats. So get this. The president is angered by a Washington newspaper's report saying that some Democratic lawmakers released a video urging members of the military to ignore unlawful orders. In fact, look at this. Trump said on Truth Social this morning, "This is really bad and dangerous to our country. Their words cannot be allowed to stand. Seditious behavior from traitors. Lock them up." And then, a short time later, the president finished with this thought: seditious behavior, punishable by death. Heavy words there. Let's talk about them. CBS News White House reporter Willie James Inman joins us now from the White House. So, Willie, take us through what prompted these posts from the president. He is clearly triggered by something.
Yeah, that's right, Reed. Well, this video was posted on social media. Democratic lawmakers who also served in the military posting this message to troops, saying essentially that they don't have to follow an unlawful order. Then you saw Trump's response.
Okay, so this is a story about some of the most damaging recordings and documents ever assembled against an American president in the entire history of the Republic. Evidence that Special Counsel Jack Smith put into the public record that captures Trump in his own voice, mishandling classified national security secrets and pushing schemes to overturn the 2020 election he legitimately lost, and why the Capitol is exploding in absolute chaos over the fact that all of this horrific evidence now sits there completely untested because every single criminal case was dropped before any jury could evaluate whether Trump committed the serious crimes prosecutors said they could prove beyond a reasonable doubt. Jack Smith's extensive investigations surfaced audio and transcript evidence that lawmakers and media outlets are still treating like political dynamite months after it became public. Material that judges ordered unsealed over Trump's desperate and strenuous objections, and yet Trump is back in the Oval Office running the country with no trial on the horizon and no legal accountability whatsoever for conduct that Smith said would likely have resulted in criminal conviction. But before we go any further, real quick, let's be honest. You can't really trust headlines anymore. That's why we built Pump Politics to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
Jack Smith is reportedly ready to go on a counterattack as the Trump administration continues to target Smith and the FBI agents who worked on his team. The New York Times is reporting that Smith has, quote, told people in his orbit that he welcomes the opportunity to present the public case against Mr. Trump, denied to him by the Supreme Court decision asserting broad presidential immunity from prosecution and adverse rulings from a Trump-appointed judge on the federal bench in Florida. The paper continues that in two recent interviews, Smith has made it unmistakably clear that he will not only defend himself, but take a hammer to Mr. Trump's exaggerated or false claims about his work as special counsel. Joining us now, former state attorney for Palm Beach County, Florida, Dave Arenberg. Dave, thanks for joining us. So let's talk about this. You know, as discussed, there was a real thought that these legal cases would have been Donald Trump's doom in his presidential campaign. That was not the case. Only one actually got to trial, the matter in New York that most around Trump believe actually helped him win. The other cases were delayed and then scuttled altogether, in part by the Supreme Court ruling.
Let me walk you through what recordings and documents are actually sitting in the public record right now, because understanding what Smith put before judges and ultimately before the American people is absolutely essential for grasping why there is so much fury and chaos over the enormous gap between what the evidence clearly shows and what the legal system ultimately did with it. One of the single most damaging pieces of evidence to emerge from these investigations is the famous Bedminster audio recording, a recording from July 2021, where Trump is heard at his New Jersey golf club, showing guests what he himself explicitly describes as a highly confidential Pentagon plan to attack Iran. On this recording, Trump explicitly acknowledges in his own voice that he did not declassify the document he is waving around and that he cannot declassify it now because he is no longer president and no longer has that authority, completely and utterly undercutting his public defense that everything stored at Mar-a-Lago was somehow magically declassified through presidential authority he supposedly exercised while still in office. Think carefully about what that recording actually means for Trump's defense and for understanding what prosecutors had assembled against him. Trump's entire public defense in the classified documents case was built on the claim that he had declassified everything and therefore could not possibly be charged with mishandling classified material because there was no classified material to mishandle. But on his own recording captured in his own voice with his own words, he explicitly admits he is showing people a highly confidential document that he did not declassify and that he cannot declassify because he no longer has presidential authority to do so. He admits on tape that he is discussing extremely sensitive national security material with people who do not have security clearances to see it. This was not prosecutors interpreting ambiguous evidence in the worst possible light or spinning facts to make Trump look bad. This was Trump himself admitting on a recording exactly what prosecutors accused him of doing in the criminal charges they brought. In the election interference case, Judge Tanya Chutkan unsealed a massive 165-page filing from Smith's team in October 2024 that laid out in devastating and granular detail how Trump allegedly resorted to crimes to stay in power after losing the 2020 election to Joe Biden. They laid out in devastating and granular detail how Trump allegedly resorted to crimes to stay in power after losing the 2020 election to Joe Biden. Filing described extensive pressure campaigns on state officials across multiple battleground states and intense sustained pressure on Vice President Mike Pence to refuse to certify the legitimate electoral results and the use of what Smith characterized as fraud and deceit to disrupt the legitimate vote count and certification process that was supposed to transfer power peacefully. The filing referenced recordings and transcripts of key calls and Trump statements as part of the evidence that would prove these serious charges at trial. Then on October 18, 2024, Judge Chutkan ordered the release of approximately 1,800 to 2,000 pages of redacted evidence that Smith had filed under seal over Trump's desperate objection that publication of this material would constitute election interference just weeks before American voters went to the polls to decide whether to return him to the presidency. Trump's lawyers begged the judge to keep all of this damaging material sealed and hidden from the public until after the election, arguing that releasing it would unfairly influence voters by showing them evidence of alleged crimes before they cast their ballots. But Judge Chutkan rejected that argument and ordered the evidence released to the American public because she determined that transparency served the public interest. The evidence trove that became public as a result of her order included extraordinary material that Americans had never seen before in such complete form. The full unredacted transcript of Trump's infamous Find Me 11780 votes call to Georgia Secretary of State Brad Raffensperger, where Trump directly pressured the state's top election official to find exactly enough votes to flip Georgia's results in his favor by 1 vote more than he needed. Images of the actual fake elector certificates that were created in multiple states Biden legitimately won as part of the scheme to give Pence or Congress an alternative slate to count instead of the real legitimate electors chosen by voters. Internal memos from lawyer John Eastman laying out the legal theories such as they were for how Pence could refuse to certify the election or send it back to the states. Exhibits and interview excerpts from witnesses who had been inside Trump's inner circle during the critical period and could describe exactly what was said and planned and who knew what. All of this material, the Bedminster audio, and the unsealed filings, and the nearly 2,000 pages of supporting evidence now sits permanently in the public record for anyone to review and evaluate for themselves. And Jack Smith, in his January 2025 final report, told Congress and the American public explicitly and unambiguously that taken together, the documents and recordings and witness statements were strong enough that a jury would likely have convicted Trump on federal charges if he had not regained the presidency by winning the 2024 election. Smith wrote that the evidence was sufficient to obtain and sustain a conviction at trial, meaning prosecutors believed they could prove the charges beyond a reasonable doubt and that any conviction would survive appellate review. All right, so let me walk you through in much more detail what specific recordings and documents Jack Smith put into the public record and why this evidence was considered so extraordinarily damaging and what Smith ultimately concluded about what it proved before every single case collapsed and Trump escaped without ever facing trial or a jury verdict on any of these serious charges. Because understanding the actual content of what Smith assembled through his extensive investigation is essential for grasping why there is such fury and chaos over the outcome and why lawmakers and commentators continue treating this material as political dynamite, even though no jury will ever be asked to evaluate it. The Bedminster audio recording is probably the single most damaging piece of evidence that emerged from Smith's classified documents investigation, and it is damaging precisely because it captures Trump in his own voice, admitting to conduct that directly and completely contradicts his entire public defense strategy. The recording was made in July 2021 at Trump's Bedminster Golf Club in New Jersey during a meeting with people working on a book project about his administration. On the recording, Trump is heard discussing what he describes as a highly confidential Pentagon plan related to potential military action against Iran, waving what sounds like a physical document while speaking. What makes the recording so absolutely devastating for any legal defense is what Trump says on it about the document's classification status. Throughout his public defense of the classified documents case, Trump had repeatedly claimed that he had the authority as president to declassify any document, He won it simply by thinking about it, and that he had exercised that authority before leaving office, meaning everything stored at Mar-a-Lago was supposedly declassified, and he could not possibly be charged with mishandling classified information that was no longer classified. But on the Bedminster recording, Trump explicitly contradicts this defense in his own words captured on tape. He says directly that he did not declassify the document he is showing his guests. He acknowledges explicitly that he cannot declassify it now because he is no longer president and no longer has that legal authority, and he is clearly aware, based on his own statements, that he is showing sensitive national security material to people who do not have the security clearances required to view classified information. This recording was cited by Smith as absolutely central evidence in the classified documents indictment because it showed Trump knew the documents were still classified and showed them to unauthorized people anyway, despite that knowledge. It was not prosecutors making inferences from circumstantial evidence or interpreting ambiguous facts in the worst possible light. It was Trump himself admitting on tape exactly what the criminal charges alleged he had done. CNN obtained and published this recording in June 2023, and it immediately became a major national news story because of how directly and completely it undercut Trump's public statements about declassification being his defense. The unsealed filing from October 2024 in the election interference case represented Smith's most comprehensive public presentation of evidence showing how Trump allegedly attempted to overturn the 2020 election through criminal means rather than legitimate legal challenges. The 165-page filing was Smith's response to the Supreme Court's July 2024 immunity ruling, which required prosecutors to carefully distinguish between official presidential acts that might be immune from prosecution and unofficial conduct that could still be prosecuted. Smith used the filing to lay out exactly what evidence he had assembled and how it demonstrated that Trump was acting as a desperate candidate trying to steal an election rather than a president performing his official constitutional duties. The filing stated explicitly and directly that after losing the 2020 election, Trump resorted to crimes, using that exact phrase in a formal court document filed under the Federal Rules of Criminal Procedure. It described in extensive detail the pressure campaigns that Trump and his allies conducted in states Biden had legitimately won, pressuring state officials to change vote counts or find problems with results that could somehow justify overturning the legitimate outcome. It detailed the intense and sustained pressure on Vice President Pence to refuse to certify the electoral votes on January 6, even after Trump was told repeatedly by lawyers and advisors that what he was asking Pence to do was illegal and unconstitutional, and that Pence simply did not have the authority to do it. The filing described in detail the fake elector scheme, where Trump allies in Arizona and Georgia and Michigan and Nevada and New Mexico and Pennsylvania and Wisconsin recruited people to sign documents falsely claiming to be legitimate presidential electors, even though Biden had won those states and the real electors had already been certified under state law. It explained how these fraudulent certificates were transmitted to Washington, D.C., with the goal of giving Pence or Congress an alternative slate to count instead of the legitimate electors who actually reflected how voters in those states had voted. And it described how Trump allegedly exploited the chaos and violence at the Capitol on January 6 as part of his scheme to stay in power, rather than acting immediately to stop the attack as any normal president would have done. When Judge Chuck Kahn ordered the release of approximately 1,800 to 2,000 pages of additional evidence on October 18, 2024, the American public got access to supporting material that had previously only been described in court filings, but not actually available for review. The full complete transcript of Trump's call to Brad Raffensperger became publicly available, showing exactly how Trump pressured Georgia's Secretary of State to find me 11780 votes, which was exactly one more than the margin Biden won Georgia by. This call had been partially reported and quoted before, but the complete transcript showed the full scope and intensity of Trump's pressure campaign against the state official responsible for certifying election results. Honestly, the released evidence included actual images of the fake elector certificates that were created as part of the scheme, physical documents that falsely claimed to represent the legitimate electors from states Biden had legitimately won. Seeing these documents made concrete what had previously been described in abstract terms in news reports. These were fraudulent, official-looking certificates with signatures and seals created to support a scheme to overturn a legitimate Democratic election and keep Trump in power against the will of voters. Internal memos from John Eastman were released showing the legal theories that Trump's team developed to justify having Pence refuse certification or take other unconstitutional action. These memos demonstrated clearly that this was not a spontaneous idea that arose on January 6, but a planned strategy with lawyers developing theories, however legally flawed, to support unconstitutional action to keep Trump in power. The memos showed the deliberation and advanced planning behind what prosecutors characterized as a criminal conspiracy to obstruct the peaceful transfer of power. Interview excerpts and exhibits from witness testimony gave the public insight into what people inside Trump's orbit would have testified to under oath at trial. These witnesses had direct firsthand knowledge of what Trump said and did and knew during the critical period between the election and January 6. Their testimony would have provided direct evidence of Trump's state of mind and criminal intent, showing what he knew about the fraud claims being false and what he understood about the illegality of what he was asking people to do on his behalf. All of this evidence was released over Trump's vehement and strenuous objection through his lawyers. His legal team argued to Judge Chuck Kahn that releasing this material just weeks before the 2024 election would constitute election interference, that voters would be unfairly influenced by seeing the evidence against Trump rather than making their decision based on other factors. They essentially argued that the American public should not see the evidence of alleged presidential crimes before deciding whether to return Trump to office. Judge Chuck Kahn rejected this argument entirely and ruled that the public interest in transparency outweighed Trump's preference for secrecy. Jack Smith's final report, released in January 2025, after all the cases were dismissed, brought all of this evidence together and stated Smith's conclusion about what it proved about Trump's conduct. Smith wrote that the evidence, the documents and recordings and digital forensics and witness testimony was sufficient to obtain and sustain a conviction at trial. He was saying explicitly and clearly that prosecutors believed they could prove beyond a reasonable doubt that Trump committed the charged crimes and that a conviction would survive appellate review. NPR summarized Smith as saying the evidence would have led to Trump's conviction, but for his 2024 election victory and the Department of Justice policy against prosecuting a sitting president, regardless of what they may have done before taking office. Okay, so let us break down exactly what this situation means and why the Capitol is exploding in absolute chaos over horrific recordings and documents that are now sitting permanently in the public record, completely untested, because every single case was dropped before any jury could evaluate whether Trump committed the serious crimes Jack Smith said he could prove beyond a reasonable doubt. Point number 1, the Bedminster audio recording captures Trump in his own voice, explicitly admitting he is showing highly confidential national security material to people without security clearances and acknowledging directly that he did not declassify it and cannot declassify it because he is no longer president and no longer has that authority. This directly and completely contradicts his entire public defense in the classified documents case and would have been absolutely devastating evidence at trial because it is Trump himself admitting on tape to the exact conduct he was criminally charged with. Point number 2, the unsealed 165-page filing stated explicitly that Trump resorted to crimes after losing the 2020 election, using that exact phrase in a formal court document submitted under the federal rules of criminal procedure. This was not political rhetoric or partisan talking points, but a federal prosecutor's official statement to a federal court about what the extensive evidence showed about Trump's conduct. Point number 3, the nearly 2,000 pages of evidence released in October 2024 included the full transcript of the Find Me 11780 votes call to Brad Raffensperger and actual images of fake elector certificates and internal planning memos from John Eastman and witness interview excerpts, material that had previously been described in news reports but not publicly available in complete form. The American people can now see exactly what evidence prosecutors assembled against Trump. Point number 4. Smith's January 2025 final report stated explicitly and unambiguously that the evidence was sufficient to obtain and sustain a conviction, meaning prosecutors believed they could prove the charges beyond a reasonable doubt and that any conviction would survive appellate review in higher courts. This was not hedging or cautious prosecutorial language, but a direct, clear statement that Trump would likely have been convicted if the case had gone to trial. Point number 5. Trump's lawyers argued strenuously that releasing this evidence before the 2024 election was election interference, essentially claiming the American public should not see evidence of alleged presidential crimes before deciding whether to return Trump to office. Judge Chuck Kahn rejected this argument and ruled that transparency served the public interest in a democracy where voters deserve access to relevant information. Point number 6. The enormous gap between what the evidence shows and what the legal system ultimately did with it is what has the Capitol exploding in chaos and controversy. Smith says the recordings and documents were strong enough to convict a president of serious federal crimes, and yet Trump is back in office with every case dismissed and no trial ever conducted. Some are furious at the lack of any accountability, while others claim the release itself was prosecutorial overreach. Point number 7. Lawmakers and media continue treating this evidence as political dynamite because it represents a detailed, comprehensive roadmap of how prosecutors believed a president tried to subvert a legitimate democratic election and mishandle classified national security information. The evidence exists permanently in the public record, even though no jury will ever evaluate it and render a verdict on whether crimes were actually committed. Point number 8. The collapse of every criminal case related to Trump's 2020 conduct, both the federal cases dismissed when he became president and the Georgia case dropped by a new prosecutor, means the extensive evidence Smith assembled will never be tested at trial before a jury. The recordings and documents sit in court files and public archives as historical documentation rather than exhibits in criminal proceedings that could result in conviction and actual consequences. Point number 9, potential future uses of this extensive evidence include House committees reopening investigations based on what Smith assembled, or state prosecutors revisiting conduct once Trump eventually leaves office again, or historians treating the unsealed recordings and transcripts as the definitive record of how close the American constitutional system came to breaking during this period of crisis. So where does all of this leave us as the Capitol explodes in chaos over horrific evidence that documents alleged presidential crimes in extraordinary detail, but will never result in a verdict or any legal accountability? We have recordings of Trump admitting he mishandled classified information in his own voice on tape. We have thousands of pages of evidence documenting an alleged scheme to overturn a legitimate election and through fraud and pressure campaigns on state officials. We have a special counsel's explicit, unambiguous statement that this evidence would likely have produced conviction at trial. And we have a defendant who is president of the United States rather than facing any legal accountability whatsoever for any of this documented conduct. The chaos in Washington reflects a fundamental and irreconcilable mismatch between evidence and outcome that many Americans find deeply troubling, regardless of their political views or feelings about Trump. The legal system generated an extraordinary detailed record of alleged presidential misconduct, recordings and documents and witness testimony that prosecutors said proved serious federal crimes beyond reasonable doubt, and then the legal system completely failed to translate that evidence into any form of accountability because Trump won an election before trial could happen, and long-standing DOJ policy bars prosecuting sitting presidents. For Trump's critics, the untested evidence represents a profound miscarriage of justice, horrific proof of serious crimes that no jury will ever be asked to weigh and evaluate. For Trump supporters, the aggressive release of this material before the election represents prosecutorial overreach and election interference, an attempt to influence voters through selective one-sided disclosure of evidence assembled by partisan prosecutors. Both sides point to the same recordings and documents and reach completely opposite conclusions about what the outcome means for the rule of law and the health of American democracy going forward. The evidence itself is not going anywhere, regardless of how this debate resolves politically. The Bedminster audio will remain permanently in the public record. The unsealed filings and exhibits will remain accessible to anyone who wants to review them. Smith's report, stating that conviction was likely, will remain part of the historical documentation of this period. Future generations will be able to review exactly what prosecutors assembled and judge for themselves whether accountability was possible or whether institutional constraints made it impossible from the start. What the Capitol chaos reflects is the fundamental impossibility of consensus about what this outcome means for the country and its institutions. Some see a failed system that could not hold a powerful person accountable despite overwhelming evidence of serious crimes. Others see a vindicated defendant whose political enemies weaponized prosecution and lost anyway when voters spoke. The horrific recordings and documents that Jack Smith handed over sit at the center of this irreconcilable divide, evidence that proves everything or nothing depending entirely on which side of the political divide you stand. That is the story of Jack Smith handing over horrific recordings and documents as the Capitol explodes in chaos over evidence that may be the most comprehensive case ever assembled against an American president, evidence that will be studied by historians but never evaluated by a jury because the defendant won an election before justice could be served. Drop a comment and let me know what you think about all of this. Does the strength of Smith's evidence matter if no jury ever evaluates it? Should this material have been released before the election? And what does it mean for accountability and the rule of law that Trump is president again while these recordings and documents sit untested in the public record? Hit subscribe because there is much more to cover about accountability and evidence and the ongoing debate over what happens when the legal system assembles extensive proof of alleged crimes but cannot translate that proof into consequences. See you in the next one.